Hey, hey, it's Jim Marshall here with the Cottage Country Insider podcast. This is episode 4. We've got a really interesting guest this morning, or actually this afternoon. We have Kelly Draycott, who's a paralegal here in Parry Sound. Welcome to the show, Kelly.
Thanks, Jim.
I'm glad to have you on. Can you kind of, in a nutshell, tell people what a paralegal does beyond what a lot of the stuff we're going to talk about, residential tenancies?
A paralegal has limited scope, as in we can't do the same thing as lawyers, such as real estate transactions, superior court, which is claims over $35,000. What paralegals, such as myself, practice is landlord tenant board, which is a tribunal that deals with landlord and tenant disputes.
Mm-hmm.
And the other main focus is small claims court, which is any type of civil action that the monetary value is $35,000 or less. So that's the main components of a paralegal. Paralegals also do traffic tickets, stuff like that. I'm fortunate enough, I'm one of very few in Ontario that is also a prosecutor, for instance, with a few municipalities around this district, where I focus on Part 1 and Part 3 offenses when it comes to bylaw and fire code infractions. So that's the main scope of paralegals.
So you would do, like, if there was a noise complaint, if somebody had, I don't know, a cottage rental and there's people there, then if the municipality had a bylaw saying you can't have them or rules, then you'd be prosecuting the owners of the property.
That is correct, and the charges are laid by the municipality bylaws. And if the person wants to dispute the Part 1 charge, there would be a trial, and that's what we would prosecute. Part 3 is an actual summons, which is a more serious offense for different infractions, where it automatically leads to automatic court appearances.
Now, would you have those in front of a judge, someone's acting as a judge, or a JP?
It's all these matters are in the provincial offences court, which is in front of a justice of the peace.
For the justice of the peace at the Parry Sound Council chambers.
In this jurisdiction, yes. And fire infractions, for homeowners and landlords are very, very serious. If it's owned by an individual, the property, the maximum fine per count is $50,000 and or 1 year imprisonment. If it's owned by an incorporation, it's $100,000 and or 1 year of imprisonment. So sometimes when I receive a summons with the information, some landlords are being charged, or owners, 15 to 17 counts on one information. Well, you do the math.
Wow.
I actually had a conviction on a property owner in Parry Sound approximately 5 years ago, which was in the paper, and I think his fines totaled, just off the top of my head, $124,000, and it was one of the highest fines ever levied against a property owner in Ontario without a fatality. So that's how serious the offenses are today.
Wow. Wow. And these are tenanted buildings that don't have proper smoke detectors, things like that.
Smoke detectors, means of egress is huge. Means of egress for the layperson is hallways need to be clear, stairways need to be clear. There can't be bikes in it. There can't be barbecues in it. Fire separation is huge when it comes to apartment buildings. Those are some examples.
Well, we always say when we're dealing with a residential tenancy or whatever, it's a good idea to bring the fire, whoever the fire in the fire department they're designated is, and to do a walkthrough of these places and just say this needs to be changed, this to be changed before there's any type of complaint.
It's interesting you say that, Jim, because of my, I don't know, 18 years or whatever. By working with landlords, once I got involved with the one municipality that hired me, there was a myth that from landlords or property owners that if you brought in the fire prevention officer and there was a problem, they would charge you automatically. That's a myth. Yeah. You invite them in as a prosecutor. We want compliance. We want people safe, and that goes right back to the firefighters, that if there's an issue, they're put in danger. And, you know, that's why I was brought on, and especially at that time, by working with approximately, I don't know, 85–90% of the landlords here in Parry Sound. I broke that myth, and it has been successful, like you say, to bring in town, it's Mr. Tuck, and he does an overview, and you know exactly what needs to be done. There's no charges. You know, it's a service, and for proper reason.
Well, it's incredible the amount of myths that go around the Residential Tenancy Act, which is the legislation that is the blueprint, the legal blueprint for tenancies in Ontario. So can you kind of paraphrase in like a minute? We could talk about Residential Tenancy Act for half an hour, but can you kind of give an overview of what it does?
Well, and you said myths. The biggest myth was that you could never evict a tenant in the winter. That was the hugest myth. You can evict a tenant at any time, any day. That I don't know where that started, but that's another story. But Residential Tenancies Act is a tribunal, once again, that is based on disputes between landlords and tenants. 99.5% of my work is for landlords. I barely ever jump on the other side, I call it. The Residential Tenancies Act is, well, about 600 pages.
Hard to paraphrase.
And over reading, over instances over the years, you become familiar with every act, every section within the RTA. And the greatest part about the Residential Tenancies Act, it's actually written to protect landlords. What a landlord must do. It's very clear, you know, the notice, what you should do in certain circumstances. The bias that comes is, number one, the delay to get into court. Pre-pandemic, we were approximately 2 months out for a hearing, maybe 3 months out. Since the pandemic, we started back practicing, I want to say in August, September of 2020. And at that time, there was a backlog of approximately 8 months for a hearing. I am a stakeholder. I go to meetings with the Landlord Tenant Board, and things were going to change. We were supposed to catch up. I can tell you as of today, we're still 8 months behind. Nothing has changed, which is the bias towards landlords. There's no shortcuts to the Landlord Tenant Board. There's no fast process to the Landlord Tenant Board. It is what it is. And the other bias is that landlords have to pay me or a paralegal or a lawyer to represent them. All tenants get free duty counsel provided by legal aid. So every tenant has representation, and the bias comes also with the landlords. Some landlords do it self-rep, as in they have that right. But anybody that has ever been dealing with a tenant and has dealt with a termination form, which is an N4, an N5, an N12, there's something called termination dates, and they're very important if they're 14 days out, 20 days out, 60 days out, fixed terms. If you're out by 1 day and you've waited 8 months for a hearing, and that tenant owes you $20,000 and you're out 1 day, the application is automatically tossed, and you are told to start again.
Back in the old days, and I'm not going to go back too long, but back 10 years ago, we in our industry normally would serve notices for purposes like, you know, vacant possession and things like that. Right now, because those timelines are just so not hard to do, you know, to be compliant when you're not doing this all the time is difficult. That's why, you know, we have our landlords contact you and have you do it, just to make sure, because, you know, 8 months becomes 16 months in one day with a bit of a screw up. It's not worth it.
I had a situation 2 years ago on a resident in Parry Sound where a real estate agent actually did the N12 notice, and it was coming up, just off the top of my head, July 31st. That real estate agent informed that seller that if that tenant didn't move out on that day, the OPP would show up and toss the tenant. Well, I get a phone call, I believe it was like July 29th, and I had to give the bad news to that landlord of this pending sale that couldn't close because the tenant wasn't going anywhere. And furthermore, the N12 was defective. It was done incorrectly. And furthermore, real estate agents can't sign a notice as per the Law Society rules. We had to start again. And there was another person that was supposed to move in. They sold their house, so they were living in a hotel. It was just, it went everywhere. And it probably took me 7 months to finally get rid of that tenant and for that real estate transaction to close. Wow.
Well, there's, and then you, once you get the notice and you get, so you go to the tribunal, you have the authority from the tribunal to be able to say evict and get vacant possession of a unit. How long does it take from that point to when the tenant actually leaves, and what's that process?
Well, it depends what type of application to start with. So if it's a rental arrears application, and let's say I appeared today, and the tenant, it doesn't matter if they owe $2,000, $10,000, $20,000. A standard order, they're provided 11 days from the date of writing the order for that tenant to pay those arrears. If they do, then the order is null and void. That's the end of it. If they don't, then at the end of that period, you're able to hire enforcement, which is AKA the sheriff, that costs $315 plus mileage to come in to evict the tenants. And that usually right now is taking approximately 3 weeks, and down in Barrie, it's approximately 3 weeks as well. That's the areas I deal with. But the problem is, because of the backlog through the LTB and them trying to run as many hearings, there's another issue going on. What I said was the date of signing the order. I've had, such as a hearing today, I might not get the order for a month and a half, 2 months. And then there's your bias again. I can't do anything without that court order. And there's issues with the system. I believe in the system, and hopefully these flaws are corrected at some point. The Landlord and Tenant Board, they did hire approximately 35 new adjudicators about a year ago to help relieve the backlog. And as I stated, it hasn't relieved anything. I would suggest that there's even more and more applications towards the board.
I've heard scuttlebutt in the circles that I kind of run around, in that there are going to be some changes that were supposed to be coming this winter to the act from the from Queen's Park. We haven't seen anything yet come through, but we'll have to kind of keep our ears kind of out for that if there's any changes to the legislation.
I wouldn't hold your breath.
No, it's, you know, we get a lot of people on our business. We were talking a bit before we started recording the podcast about, you know, we got calls from people. I've got some money, thinking about getting into being a landlord, and I always kind of sit down with them a little bit and say, look, it's not probably what you think it is, where you just collect a check every month, kind of like Mr. Roper from Three's Company. I don't know if you're old enough to remember that, but it was, you are, okay. So it's not like that. It's much more active. I've had rentals before. I've sold my rentals because of the time commitment to do them. So, you have to kind of really have your eyes wide open when you're going to do this.
And Jim, like I stated previously, that to come in, be tight on a mortgage, and a tenant stops paying, it's called a rainy day. And if that landlord has to have the capability to deal with that rainy day, which means no rent's coming in, possibly damages in that apartment or house or this investment property. And also the next part is to have that money to pay somebody like myself to represent you and go through this 8-9 month debacle. I personally feel that there's a lot of investors, like you say, they look, oh, my mortgage is this, and this is how much the rent's going to be. This is going to be great. I'm sure that does happen out there, and congratulations to those property owners. But I see the other side, and personally, I wouldn't be a landlord for all the tea in China. I do understand the strengths, but I've been tainted in my last 20 years of what I have seen. And in my opinion, there's no protection for landlords.
No, I'm not going to disagree with you on that. It is rather one-sided on the tenant side. One of the things that we, because again, we deal with people from all sorts of, landlords, tenants, homeowners, all sorts of things. But, a lot of the things out there, as far as fallacies, first and last month rent, rent deposits, damage deposits, you can't smoke in your unit. Like, how many of these things are actually fallacy, and how many are fact? Because there seems to be a lot of fallacy out there.
One thing the Landlord Tenant Board did do a few years ago was make a standard rental agreement. That was a major step forward for everyone, including tenants, landlords, everybody. And that standard form is very easy to complete, and it deals with a lot of the issues of clarification. Who's paying the hydro, for instance? What is the rental agreement? What are the terms? Who are the parties? Notices can be served by email. It benefits everybody. The fallacies that you speak of is, yes, there is a first and last month's rent, non-issue. Security deposit, no such thing. You can put it in your rental agreement, no smoking. That's a non-issue. But the person can walk into your apartment and start smoking the very next day. Then, yes, you can serve an N5 under enjoyment of living of others. That will take you 8 months to get rid of that tenant. Yes, you could sue for damages under that N5 as well. But good luck to get that money out of them, and the damages are already going to be done. No cats, no animals. Once again, a fallacy. Yes, you can put it in your rental agreement, but a person can walk in with a dog, 6 dogs, 6 cats the very next day. I remember having an issue here in town where it was a triplex where there was a shared washer dryer, and the landlord was very clear, no pets. The one tenant was somewhat deathly allergic to cat hair. Well, the new tenant moved in and brought in 6 cats. So here we are in a situation, if you can imagine, under the door, hair will, move. And also this shared washer dryer where hair, cat hair gets on people's bodies, socks, whatever. And it was a real bad situation. And I was able to get it resolved fairly fast. And I want to say 3 months or 4 months. We didn't even have to make a hearing. But it was devastating for the landlord and that one tenant. Once again, I do small claims court where breach of contract, is punishable. In this circumstance, yeah, there's a breach of contract, but if that tenant wanted to protect their rights, which they have a choice, it would have taken us 8 months. And quite frankly, there was no recourse to the tenant. The tenant would have been just evicted. There's no damages. There's no financial payout. There's no court costs in landlord-tenant board. So quite frankly, for a tenant, their end of the day would be just eviction, where damages, financial damages, property damage, such as smoking or whatever, landlords are in a real worse position to deal with problems than tenants.
So kind of circle back a little bit. What can landlords do to effectively screen tenants?
And once again, if you can imagine, with the majority of my landlords, I don't move them in, I move them out. That's my job. I don't get into the process of moving in tenants, but there are credit checks that are available. There's also employment. You can ask for pay stubs. You can do references. And where I say references, such as somebody says, I work for Jim Marshall. Well, you call Jim Marshall. A lot of, I've seen over the years that there's references in there that I've lived at Joe Blow's house for the last 8 years, and the rent was $1,500. Here's the number. So they phoned Joe Blow, and Joe Blow, great tenant. Well, who's Joe Blow? The point is behind it is lots of times it's turned out to be somebody's sister or boyfriend. They never lived there, you know. So I heard one comment a couple of weeks ago, which I found interesting, as in if somebody wanted to rent your property, and let's say we're in Parry Sound, and their present address is 6 Church Street. I'm just throwing out an address. Go do the rental application at their property.
Yeah.
Think about it. You'll see what the place looks like. You know, you can get a little bit of information of why they're leaving, if you know what I mean. So you know, again, you have to do your due diligence. There are numerous great tenants out there. I will say that. I'm just poisoned by the few bad ones.
I've got a bit of a theory on why we have bad tenants, and it comes down to, in my opinion, and you might disagree, some other people might disagree, but you know, if you look at the waiting list for social housing in a town like Parry Sound, it goes, I think it's about 10 or 12 years right now. So I think a lot of tenants that end up coming into these places, and I'm not going to say the specific, but there's a large one that opened in Parry Sound back about 1.5 years ago, and about half the tenants that moved in have moved out because they can't afford it. There's been issues where they've had to remove some of the tenants out of the building. But you know, I get it, and a lot of these people are having problems with addiction, mental health issues, and I think there's a big failure there in social housing in a town like Parry Sound, especially with the waiting list. There's no money, there's no property, and people have to have a place to live.
I have a lot of personal comments, which I won't get into, of why I think some of this stuff happens. But going back to square one, the hub here in Parry Sound, I was a little bit skeptical, but it's turned out to be a great facility. And I think there should be more places like that erected in our, like Muskoka, Parry Sound, everywhere.
I was I'm going back, I was a Parry Sound town councilor back, I think that happened about 2015 to 16. It's been, yeah, it's probably been about 7 years now. We dealt with it on the council level, and I thought it was a positive thing for the whole neighborhood there, you know, and we had neighbors that would come to council and they can, you know, voice the objection to it. It's like, this is an improvement, as opposed to having schools that bells are ringing all the time and things like that. And I think it's been an absolute, I agree with you 100%. And I think, you know, having some innovative ideas for housing for people, and, you know, housing is a wide, you know, it's so many facets of it, not just, you know, from apartments to social housing to assisted housing to living with your parents in the basement. It's, I think there's some success stories out there. I think, unfortunately, there's probably just as many, if not more, non-success stories.
Well, you know, and again, the hub is, in my opinion, very well run. I like it. When it comes into my line of work, such as a purchase agreement goes through for a house, there's tenants. I give the notice, we're going to hearing. The problem is there are no vacancies out there. And if there are any vacancies, the rent is usually double from what that tenant was originally paying. So it's creating, again, 6 years ago, I would give a notice, you know, whatever. There would be a moving process, but these people have nowhere to go now. And when I'm at these hearings, even though I have a sale, I have a purchaser, I have the purchaser's affidavit, I have the purchaser at the hearing saying, yes, I'm moving in, it's minimum 1 year. It's all legit. The problem is you have a tenant that has nowhere to go. And that is the problem. And that creates a little bit of this turmoil at these landlord tenant board hearings. There's tough decisions, you know, and part of the act is the adjudicators have the discretion to prolong tenants evictions as well. And even though I have a purchase agreement that says, hey, you know, March 31st, this deal goes through or will be possibly in a breach of contract, the adjudicators don't care. They'll take that into consideration 100%, but they have to look at the big picture. And if we have a family with some children that have been tenants there for 5 years, they're going to get probably a 6-month extension because they got nowhere to go.
Like it or not. Yep. Well, absolutely. So if you want to get, and you kind of got into it a little bit there, vacant possession for using for your own use. So if I buy a duplex, for example, I'm going to live in the upstairs. I'm going to move I'm just trying to think, one of my sons into the basement apartment. Is that still doable? And
I just want to clarify that everybody uses the word vacant possession. Within the landlord tenant board, there's no such thing as an eviction for vacant possession. There has to be a purpose behind the termination of that tenant. And first of all, if there's a purchase agreement and it's an incorporated company that is buying the property, there is no such thing as a personal use as in moving somebody in. It's just you accept what is known as holdover tenants, and those tenants go with the property. Okay, so incorporated companies can't do personal use applications. Under your scenario, if there was a purchase agreement and there's an upstairs, downstairs, yes, you could evict both people under an N12 L2 application. Both tenants or both apartments get 1 month free rent in compensation. And again, we have to wait for a hearing. If the landlord doesn't move in or that person doesn't move in, the tenant can come back and seek their rental increase for 1 year against that landlord. They can also go after their moving costs. There's a fine up to $25,000 through the landlord tenant board. And I was just reading a case the other day. There's something called general damages as well. And the case that I was reading the other day, that it was down in Barrie, the landlord said, hey, I'm selling. And so told them to move out. They moved out. It was a family that husband and wife and 5 children. The landlord didn't sell the place, posted it immediately, doubled the rent, and moved somebody in. So the general damages were assessed at $10,000 because of the turmoil for those children, such as moving out of their bedroom, you know, just moving in general. And it was a hard slap, but I have no problem with that law whatsoever. Genuine intentions is what court should be about. And if anybody's trying to circumvent the rules, they should be punished.
Yeah. What about getting possession or vacating a tenancy because you're doing renovations on the unit or on the building that necessitates having the unit vacant, and you're going to be getting a building permit and all that to do that? What are the rules around that?
So that's known as an N13 notice. It's 120 days notice to the tenant, but once again, we're into 8 months. If the complex is more 5 or more units, we have to pay 3 months compensation. If it's less than the 5 months, it's 1 month compensation. It actually terminates the tenancy, but it has to be major renovations. It's not changing the flooring, it's gutting the place. And for landlords, it's somewhat a high bar to hit to get that termination. And it is a termination. That tenancy is terminated on X date, and those people have to have all their items removed out of this house, this apartment, whatever. The scenario comes into play that the tenant can ask for first right of refusal, which means once the place is renovated, they can move right back in at the exact same rent. So,
which is you know, there's a lot of reasons why a lot of apartment buildings don't get a lot of work done to them.
And again, I won't go down those streets, but you know, it's a catch-22. A lot of the N13s that I get involved with are major renovations. I usually try to offer tenants extra compensation because of their move, and because we are going to be maybe 6 months, 9 months on the renovation, they are going to find other accommodations. So I'll give them more money to waive what is known as a T5 application, and waive their rights to their first right of refusal, which when that date comes of termination, that's the end of it. There's no down the road, which means the landlord could sell the place, he could move in, he could re-rent it. But, you know, and also that is only on consent. That tenant has to agree to that.
What about, there's a lot of talk, and I think the catchphrase is cash for keys. So I want to have vacant possession. Here's the cash. You give me the keys. We'll change hands and you're out of here. Is that legal?
100% it is. It's residential tenancy agreements are between adults, not with any minors. And 2 adults can make a binding agreement at any time. The cash for keys, I've done a lot of them. They vary in dollar amounts. But it comes with something called an N11, which is an agreement to terminate. The N11 has always been the golden grail to landlords. If a tenant and a landlord agree on termination, an N11 must be signed. A text message, an email, doesn't hold any water with the landlord and tenant board. So it must be on an N11. The cash for keys does work. It is legal. But as I previously stated, over the last year, I've entered into all kinds of negotiations trying to get, for instance, a real estate deal done where there possibly could be a breach of contract because we can't close. But tenants, even though I may offer $5,000, $10,000, they're really not interested in the $5,000 or $10,000 because they have nowhere to go. It's fine to have $5,000, $10,000, but they're going to sleep on a park bench. And I have numerous ones going on right now. It's not about the money. It's about where are these people going to live? And that's the problem with cash for keys. I strongly suggest that to numerous clients all the time under free advice to try to work it out with the tenant before I get involved. Instead of paying me, pay the tenant, right? But I want to say 85% of tenants right now are actually thinking of, but where am I going to go? And I totally agree with them. And they may be paying $1,000, they're going to pay $2,000. They may be going from a house to an apartment. Well, they don't want to live in an apartment. The problem is once the process hits the landlord tenant board, if the paperwork is done correct, they do have to leave. And then they're throwing away the cash for keys deal that was previously there. So it's a real catch-22 for tenants. I encourage all tenants all the time to deal with duty counsel. Our office is out of Bracebridge, and duty counsel out of Bracebridge gives solid advice to these tenants of there's a pro, there's a con. Yes, you can hold off for 5-6 months, but this is still going to happen. So it's tough on tenants. It really is.
Yeah, because they call me. And, it's like, do you have any apartments? Do you know of anything? And, the effective vacancy rate in the town of Parry Sound the last 3 years has been really zero. There haven't been. People gave 30, 40 applications for an apartment. So it's a huge issue. What about yearly increases? I know that landlords are limited by law how much they could increase. I think that's 2.5% for 2023.
That's correct. It's 2.5. There was a 2-year freeze through the pandemic. And then one is provided to a tenant with 90 days notice for the rental increase. I tell every landlord, even though the 2.5, for instance, right now doesn't sound a lot on, let's say, $1,000 rent, it's $25. It will add up, and you have to do it, even though it doesn't sound like a lot of money. You have to do it. The sad part is it's only 2.5%, where we all know material, gas, everything is a lot more than that kind of increase. But why there is this guideline is because they have to protect the tenants that landlords can't jump. And I have so many landlords right now that have actually demolished their properties and done rebuilds over the last couple of years because Ford's government a few years ago, can't remember the year, brought in on any new build, and I believe it was from 2019, I just can't remember. Any new build, there is no rental increase guideline. So a lot of investors are buying older buildings where the rents are lower, doing an N13 for demolition, knocking these places to the ground, investing in new builds, which they're not under the rules of rental increases governed by the RTA. And so these landlords, if they do have a problem tenant, the first thing they do is jack the rent by $1,500.
Well, the issue when you don't do the yearly rentals, and we see it in Parry Sound often, where there was a building, I think, 2 years ago for sale down the street from me. It was a fourplex. It was built in the late 1980s, and one of the tenants was still paying $800 and some odd for a 2-bedroom, 1,100 square foot, because as they said, well, they generally don't increase the rent year by year. Couldn't sell that building for a long time because the rents didn't support the value.
I have one over in Bracebridge that the average rent is $600 on 7 units. The landlord never raised the rent over 15 years. Landlord got ill. decided to sell, the investors have come in and bought it under a demolition.
Yeah.
And once again, what are we doing? We're wiping out tenancies, affordable income or affordable housing. And, you know, that's for another political show.
Well, that's what the whole legislation has to be looked at, because, you know, you have to look at kind of down the line how these things are going to affect tenancies. And, you know, the government, the provincial government is talking about building more housing, the federal government, but, you know, how these are part of the solution. And these have to be, it's not just building homes up on the Greenbelt north of Toronto or whatever. It's, you know, like building tax incentives for or grants or something. It's hard to even get money to build. You want to build an eightplex in Parry Sound right now. Try to get funding for it.
And, you know, it's interesting you said that about, you know, possible development and these plans coming in. But we all know that's going to be 10 years, maybe 14 years down the road. How is a place just like Parry Sound going to survive with no occupancy? You know, if people like it's mind-boggling that this stuff hasn't been an ongoing problem. Yes, we did get an influx of a lot of purchases, as you're well aware. And I was involved in numerous sales where we got flooded from Toronto, buying properties here. I was evicting tenants. But let's say it was an upstairs, downstairs house. The people from Toronto bought, moved in personally, but we just lost 2 rental units. I personally probably in 1 year did 50 of those. Well, there's 50 rental units. You know, and upstairs, downstairs, that's 100.
We see it in hotels in the area that you can't get most of the year. You can't get a hotel vacancy if you want to spend the weekend in Parry Sound, because a lot of the hotels are being rented out to people.
Yes,
workers, families. We had one last year, a family of 4 that were renting in a local hotel for over a year.
Yeah, incredible.
It's sad. It's sad, but it's just, I don't know what the answer is, but it certainly can't be done at the municipal level. It's got to come from the upper echelons of government. So
I agree.
So, well, we've been on for longer than I planned, but, you know, it's a great discussion. There's so much we could talk about. Continue on. If people want to learn more about you and maybe perhaps, you know, hire you to, you know, prepare documents or advice, where can they find you?
Well, it's, I think the easiest way is just to Google Kelly Draycott Paralegal in Parry Sound, and my web site will pop up with all the information. I really don't advertise because the amount of work that is in our area. COVID actually brought us out of the archives, and where I used to just do Muskoka Parry Sound. Everything is by Zoom with small claims court and landlord tenant board, except trials in small claims court. So if you can imagine, I do it right across Ontario now. So I can help anybody anywhere. It's just, I love to give free advice all the time, because a lot of people just need a little bit of guidance. And that's been my game plan for 20 years, and nothing's going to change with that.
Well, we'll put your contact information in the show notes as well. Kelly, thank you so much for being so gracious and giving us some time this afternoon, and we'll talk to you soon.
Okay.
Okay. Take care. Bye-bye.
Bye-bye.